Okay, good morning, everybody. I'm Tyson Smith. I'm with a planning and law firm called White & Smith. I'm out of Charleston, South Carolina. Do a good deal of impact fee work and other land use work. Got a panel up here. It's wonderful when you have three people that don't need an introduction, but their histories go back so far and have involved so many things, particularly Jim's, that, but Susan's pretty close there. But I thought I'd ask each of them to introduce themselves, and then we'll get started. So Susan, why don't you start us off?
Susan Shetley, I'm a solo practitioner here in Sarasota. I started out with Friday Collector Carlisle and Shortledge in Kansas City doing impact fee work sort of all over the country. Then came to Sarasota County in-house and had the opportunity to work on systems that I had helped create and then helped maintain them from inside for 10 years. So that gave me a lot of really good hands-on experience. And I'm going to take a couple of cases and apply them to some practical situations today.
I'm Jim Nicholas. I'm now a over-the-hill retired professor from the University of Florida.
Emeritus?
Emeritus, yes. And I've been toiling in the impact fee fields for a very long time. And it's sort of fun to come back and start doing the basics and back where we were and where it all came from. But I've had a lot of experience in terms of actually doing it and then the academic side of trying to write it up and put it in the publications and hawk it around the world. So welcome, and I'll be with you in a few minutes.
I'm still Jerry Murphy. I'm with the University of Florida's Resilient Communities Initiative, and I'm the chair of your organization for the past year. What do? I work with local governments here in the state of Florida with partnerships with the university to provide ongoing planning assistance through interlocal agreements on an as-needed basis, and try and make the conference happen this year.
Good. Thank you, Jerry. Okay, so you can see on the slide here, generally what we're going to cover in this legal basics course. Jim's going to walk us through the real basics. How do we get here? Some of the early cases. And then Jerry's going to take on the enormous task of explaining to you the difference between a fee and a tax. It's obvious to us, but not most courts. And then Susan's going to take on a really interesting task, and that's pointing out some of the issues that remain unresolved. It's always quite surprising, at least to me, particularly to my clients, how many issues, specific issues anyway, remain unresolved, and some of the legal principles we look to answer those questions when they do come up. And then I'll go back to some of the basic cases and then touch on some recent ones as well. So with that, Jim, if you'd like to get us started.
Am I up there? Yes, I am. Now. Okay, again, good morning. America imported its structure of government from England. And England, of course, had a king, the sovereign. And only the sovereign had authority. And the sovereign would then create shires and cities and whatnot, and this king would tell them what they could do and what they couldn't do. And when we set up the United States, we basically just copied that. We had counties and cities and whatnot who got their authority ultimately from the state. And if the state gave them authority, they could do it. If the state didn't, they couldn't. And that sort of got us into this whole tax versus fee thing, which Jerry's going to talk about, because if it's tax, you have to have authority from the state. If it's not a tax, you can go ahead and do it. And if you haven't been given the authority, that becomes a very important question. But when we urbanized in the United States, starting really in the first part of the 20th century, we started living closer together and we started needing things. We needed water and sewer, we needed streets, we needed parks, we needed all these things. Well, who was going to pay for it? How was it going to get there? And mostly it was sort of catch as catch can. Neighborhoods would come together and they would do it, or individuals would do it for themselves. And finally came the issue of, well, why don't we have the city do it? And then, well, okay, how do we pay for it? Well, as cities started growing rapidly, as Los Angeles did, issues arose. which is why the city of Los Angeles went to Mr. Ayers and gave him the opportunity to give to the city of Los Angeles some land that they were going to build a major road on. And Mr. Ayers says if it's for everybody, then everybody should pay for it. He sued, and here we get the California court telling us the questions of reasonableness, he was saying it's unreasonable, are don't necessarily depend on matters of fact, excuse me. It's small here that I have to read them. They're not abject ideas or theories. In a growing metropolitan area, such as Los Angeles, additional subdivision adds to the traffic burden. Perhaps could go without saying, but it does. It is no defense to the conditions imposed, because this is really the heart of the issue, that their fulfillment will necessarily also benefit the city as a whole. How do we get to the next one? Whoops, went too fast. It is the petitioner who is seeking to acquire the advantages of subdivision, and upon him rests the duty of compliance with reasonable conditions for design, dedication, improvement, and restrictive use of the land, so as to conform to the safety and general welfare of the lot owners in the subdivision and of the public. From this, we get the reasonable relationship test. On the West Coast especially, you'll hear it over and over and over again, reasonable relationship. And that's exactly where this was drawn from. East Coast, we tend to use somewhat different words, and used to be thought those were different concepts, and now we're seeing them come closer and closer together. They're really not. But here, what Los Angeles wanted was land, and land doesn't build a road. So can an impact fee be charged? Can we get money? Ultimately, that's what we want. And here out of Florida, city of Dunedin, just up the road a bit, about maybe 50, 60 miles right on the coast, where Dunedin had to expand the water and sewer system. In order to do that, they had to issue bonds. In order to service those bonds, they had to raise the water and sewer rates. And the existing residents said, why? Why are you raising my rates to give water and sewer service to my neighbor? And so the city said, that's a good point, and said, neighbor, you're going to kick in, so we don't have to raise those utility rates. Went to the Florida Supreme Court, where the court said, raising expansion capital by setting connection charges which do not exceed a pro rata share of reasonably anticipated cost of expansion is permissible. Where expansion is reasonably required, hey guys, you have to really need it. You know, it's not like it's Christmas. You can say, give me money. If use of the money collected is limited to meeting the costs of expansion. We've been doing a lot of fighting about that ever since. What are those costs of expansion? But, the court went on to say, the cost of new facilities should be borne by new users to the extent new use requires new facilities, but only to that extent. Now, there are several thrusts that come from this, and what it has to do, as much as anything else, with is repair and replacement. And what the court's saying is, hey, that's a community cost, not a new user cost. When new facilities must be built in any event, which is the replacement, looking only to new users for necessary capital costs gives old users a windfall at the expense of new users. So they're looking for something here that's, quote, fair. That you don't stick it to one, you don't stick it to the other. Find something in the middle. Well, those are noble terms, but they don't really tell us how to do any of this, but nonetheless, they're important concepts. First, can you do it? Yes. But you can't do it in such a way that you're getting a windfall. It's not a matter of can you get developers to subsidize the community or somebody else. So, yes, you can have impact fees if the amount does not exceed actual costs. What actual costs? That's one of the big issues we're going to be discussing in the next session. The so-called set credits question. Is the cost the total cost? And then what if you have a grant from the federal government to pay half that cost? Is then half the cost? Or can you charge the total cost and keep the grant? That's, of course, a simple one. There are many others that go into that. But what is that actual cost? The funds are expended to expand the subject capital, which is an earmarking question that doesn't go into the general fund. That it goes, roads go to roads, and schools go to schools, and water and sewer go to utilities. And the fees cannot yield a windfall to existing communities. This evolved into the rational nexus test. Now, what I saw in the evolution of it is the rational relationship was more of an intellectual argument. The rational nexus became a statistical argument. Today, you can find almost no difference between the two. The rational nexus test really became articulated first here in Florida again, Hollywood Inc. versus Broward County, where the court said, we discern the general legal principle that reasonable dedication or impact fee requirements, see how to put those two together? Dedication and or impact fee requirements are permissible so long as the offset needs sufficiently attributable to the subdivision. Sufficiently attributable. How much is that? Well, that's what we have all this methodology about. So long as the funds collected are sufficiently earmarked for the substantial benefit of the subdivision residents. Again, the earmarking question, which we haven't had a lot of action in. Had some, but not a great deal. Most of the arguments and fights and litigation have been over the dollars and cents of it, how much. So the rational nexus, as we've got a new term called the essential nexus, which is sort of both the two combined, is that impact fees may be no more than the actual cost of providing needed improvements to the development, and fees collected must be earmarked for the people that paid them. Again, how do you do that is an important component of it. In Banbury versus South Jordan City, a case out of Utah, is an excellent discussion of how do you do the amounts, trying to dig into what is cost and what isn't cost. Now, this is a Utah case, which many will point out to you, and applies only to Utah. However, a number of enabling pieces of legislation have picked up some or all of these concepts to try to get into it. And what it's talking about here in this is a municipal fee related to services must not require newly developed properties to bear more than the equitable share of their capital costs in relation to benefits conferred. That's really the same thing, isn't it? Can't be more than their costs. To determine the equitable share of capital costs to be borne by newly developed properties, a municipality should determine the relative burdens previously borne and yet to be borne by those properties in conjunction with other properties in the municipality as a whole. The fee in question should not exceed the amount sufficient to equalize the relative benefits of newly developed and other properties. Getting to the same thing, but you see there's talking now here about, let's look backwards. What have they paid? We're going to look forwards, what are they going to pay? And what we're looking for is an amount that equalizes these burdens. And we've been fighting about that ever since, and that's what most of this session is going to be about today and tomorrow. So, Jerry, are you next? Fee versus tax. Jerry's going to resolve that. Oops, let's skip all that. Here we go.
Can you hear me? Yeah. So this distinction, the fee versus the tax, I think Jim kind of covered the highlights, but we're going to go a little further into it. Step back a moment. There's a three-legged stool of local government. You have to have a territory that you can govern. There have to be people, most of you folks in the room, who perform the work of governing, and the elected officials and the appointed officials. And then there need to be funds to carry out the public functions. And so that's where we come in with the impact fees and the tax distinction. In the recent history, since basically the 70s, if not earlier, we've had a dichotomy between the spiraling costs of providing government and an increasing reluctance on the part of the people who live within the governing area to supply the additional revenues, taxes, to pay for that. And so we have a couple of laws, primary, not Murphy's Law, but Johnson's Law. We who have done so much with so little for so long can do practically anything with nothing. And then there's Poe's corollary, we the willing, led by the unknowing, are doing the impossible for the ungrateful. We don't really mean that, it's exaggeration, hyperbole. So there are two major sources of revenue for local government, taxes and special assessments. And it is arguable that impact fees are a type of special assessment. And then there are loans, which are usually obtained through bond finance. And then there are less significant fees and fines, licenses, and the things that come under the general police powers. And then there are grants and federal and state revenue sharing. So that's kind of, in a big overview, the basic sources of local government money. So, those of you who like to take digital capture of slides, or what I like to call phonograph 2.0, here's the take-home slide, and we'll come back to this at the end. So fees, they're a police power exaction, basically. They go to a regulatory cost center. With regard to impact fees, that cost center is providing infrastructure. They provide a specific benefit for the spending of the money, and that benefit has a reasonability requirement, which has come later on through the Supreme Court decisions to become rough proportionality, meaning that the spending of the money has to be attributable to the fees and vice versa. And finally, those who benefit should bear the cost of the benefit. Whereas with taxes, you don't really get anything but the privilege of living in the community. There has to be explicit state authority for a local government to levy those taxes. It can be constitutional, it can be statutory, it can be a blend of both. It's a forced contribution to the general revenue. You don't really have a choice. You pay it or you get in trouble. The spending can be discretionary. The local government can spend the money however they would like to, as long as it's reasonable. Proportionality is not required. And so the main differential here is that there is a general public benefit. Keep that in mind. So we'll go back to one of Jim's slides, where it says it's no defense to the conditions imposed, and this is talking about an exaction, that their fulfillment will incidentally also benefit the city as a whole. So with impact fees, there may be a general benefit that comes along with the specific benefit, because when you build a road, you can't really keep people off of the road unless it's a toll road, and that's a whole different discussion. You know, it's a road for the public. All of these are public benefits. But the demand that requires that road to be built is the thing that's attributable to new development. So now we're going to go down the rabbit hole of the Mississippi River to the great state of Mississippi. The Mississippi state flag, which I think echoes some of the problems that are still resident in Mississippi. And let's see if I've got a pointer here. Yeah, so we're going to look at Madison, and then we'll go down and look at Jackson. And these are some of the state case law, federal and state case law for Mississippi that basically defy everything that you've just been told and everything you'll probably hear throughout the course of this conference. So Mississippi demographics, overall, they rank 49 out of 50, so there's someone who's doing worse than Mississippi. This is a slide from Mississippi Burning, one of my favorite films about Mississippi. If you've seen the movie, you'll recognize the scene, and if you've not, don't mess with Gene Hackman. So here we have Madison County and the citizen of Madison, and they're just below or just above, the state capital of Jackson, which is not in Jackson County. And the first case that we're going to look at is home builders versus Madison. And here the city of Madison adopted an impact fee in 1986 to all the good reasons why we adopt impact fees. You'll have extensive language here from the case, but I'm going to go through it pretty quickly. This was brought in a 1983 action in federal court, basically saying that what the city of Madison was doing was unfair, particularly to the home builders, and so they challenged it. The city of Madison sought to have the case dismissed based on the federal law that says that basically the federal courts are not going to get involved in tax arguments if there is a state remedy available to the complainant. And so the city of Madison said, it's a tax, and therefore the federal court doesn't really have the jurisdiction to look at it. And the home builders said, no, no, it's a fee. And so the federal court should have an opportunity to do it. Now, anyone in the room who knows anything about the federal courts will realize that in modern times, the late 20th century and now, the federal courts are basically trying to get out of any decision that they could possibly not have to make. And so the court debated about this a little bit, and they said, you know, you're right. For purposes of the Tax Injunction Act, and they cast it as a broad net, this impact fee that Madison wants to impose is a tax. Therefore, we have no jurisdiction. Thank you, goodbye. Your case goes on to state court. However, in holding that it was a tax, it set a precedent, let's say, in Mississippi that they were very keen to take up. So in their discussion of whether it's a tax versus a fee, they said, Madison contends that it's a tax, and we agree. And therefore, no subject matter jurisdiction. Much more language, and I would say a little bit of convoluted logic to get there. So come forward a few more years, and the city of Ocean Springs, down on the Gulf Coast, which was experiencing growth and some issues from a little storm named Katrina in terms of having enough money to rebuild, decided that they would pass an impact fee, and they would do it better than Madison had done it. And so they adopted a general municipal ordinance and then provided impact fee ordinances for 6 separate capacities. General municipal facilities, key on that, because the court will later talk about services as opposed to facilities. And fire, parks and rec, police, major roadways, water facilities, things that we're pretty much all familiar with. The home builders said that we don't like this, and the court commented that they went through that discussion all through the hearings. This is a bad idea, and that they challenged this process to no avail. And the impact fees were paid. The other thing that the court focused on, which is important, is that the impact fees were not spent specifically on infrastructure development. They were spent on general things. And this went on from when they adopted it all the way until 2004 when the case was filed. The appeals court, the Supreme Court of Mississippi, also referred to the learned circuit judge because the circuit judge determined that these were a tax. And the city commission did a study, they adopted findings, they went through all of the things that you're supposed to do, but they had language where the calculation methodology is not cast in stone, and over time those assumptions and variables are subject to change. And I think that in finding that it was a tax, the court below and the appellate court thought that there was just a little bit too much give here. So there were 5 issues, and we'll focus on 3 of them. Is there constitutional, statutory, or common law authority for the city to adopt the ordinances and the fees? So in Mississippi, the feeling is that while they are a home rule state, they do not have the ability to utilize all of the home rule powers, one of which would be to adopt fees, at least as far as impact fees go. And then the court below did the court below err in finding that the fee ordinance was an invalid tax? And then there were a couple other issues that really aren't relevant for our purposes. So was there authority to adopt the fee? No. The state does not have a specific constitutional provision or a statute regarding implementation of impact fees, so there's no authority and none at common law. And they distinguished the Mississippi Constitution from other states because the Mississippi Constitution has a provision that basically says there shall be general laws to prevent the abuse by cities and towns and other municipal corporations in the levying of taxation, borrowing money, or anything like that. So the state courts of Mississippi and the federal court there, for that matter, don't really have a big support of local government finance. In coming up with their reasoning, they went back to the early 20th century and actually back to the 19th century to come up with cases. I think whenever courts are doing that and they're not dragging the case law forward, they're reaching. And from a jurisprudential sense, I would say that the Supreme Court of Mississippi basically gave this case to a law clerk and said, we're going to find this to be a tax, figure out how to rationalize that. And that's what they did. So, is there police power authority? No, because there's no constitutional basis, there's no legislative enactment, and your home rule powers are not the home rule powers of other states. So, they talked about the pre- and post-home rule statutes, and still the court found a distinction that there were authorities to impose fees, but the fees could not be inconsistent with the Mississippi Constitution, and the fee as opposed to a tax is discussed further. And finally, did the court err below? No, and a lengthy discussion that they wrapped all around the ability to find out that, and again, here we go back to 1893, that the principles do not apply generally, so that if the language in the enabling ordinance, the first ordinance of the other six that provided for the fees, says that it provides a general benefit to persons, then that's not specific enough. Again, we go back to Ayers where they said that's not the case, but this court did not cite Ayers or any of the Supreme Court decisions, the United States Supreme Court decisions that followed it. They talked about special assessments and they distinguished it from being a special assessment. And then finally, the court decided that it was a tax and therefore the city had no authority to levy it. The takeaway line, again, is this slide. These are the real distinctions between fees and taxes, and no matter how convoluted your argument is, this is where it should turn out, except in the state of Mississippi. If you're going to try and pass an impact fee in Mississippi, you better go to the legislature and have one adopted. And part of the discussion in the Ocean Springs case, they talk about Governor Haley Barbour at the time, who was actually supporting legislation to pass impact fee authorizing statutes. But that has not happened, did not happen then, and it hasn't happened since, despite Katrina. We'll see how Nate does for them. And so I'm going to pass this now on to Susan, and thank you very much.
Well, let's move forward 10, 15 years. I have to tell you that because you'll find that most of the same issues that Jim and Jerry just talked about are still out there, the courts are still struggling with, and practitioners and local governments are still struggling with them. You would think by now that a lot of this stuff had been resolved. The legal principles are worth repeating. I'm actually not going to repeat them right now because you've just heard them and you'll hear them a bunch more times over the course of this conference. Just to let you know, from Ayers and those very early attempts to transfer some of the costs of providing public infrastructure, we started out with water, sewer, parks, roads, library, police, fire, a lot of normal stuff that we're used to seeing. We're also seeing lots of emerging fees or less common fees, affordable housing, workforce housing, mobility fees, attempts to move into using impact fee funds for operational costs. Recently, after Irma came through, I'm hearing people talk about hurricane evacuation impact fees or hurricane shelter impact fees. So everybody's still pushing forward on lots of different ideas. I'm going to lay these rules out here because I'm afraid I'm going to run out of time if I don't do it right now. These are the rules that I always talk to all my clients about. The legal principles apply still. They applied in the beginning, they still apply. They apply to all phases of the process. development of your documentation, adoption, appeals, waivers, administration, how you spend the money, those legal principles need to be foremost in your mind all the time. At the same time, there's rarely only one right answer, which means you have to be very careful how you craft changes over time, which leads to don't burn your methodology bridges. I was fortunate enough to work on Sarasota County's impact fee systems for almost 15 years. In that time, we had several economic downturns and upturns, and we also had several complete shifts in political focus, from developers should pay all the way everything max growth control to developers are wonderful, they should do everything that they want to do. So what may be the ugly duckling of a methodology today, in 2 years, 3 years, 4 years, may be the swan that your new set of elected officials want. So carefully craft those changes over time. Make sure your outside consultants do that. Not everybody, but there are some consultants that come in and want to trash what somebody's had. That's very easy to do. It's hard to restrain yourself sometimes and say, okay, no, let's build a bridge from this to the next one. And absolutely, absolutely, absolutely follow all the procedural requirements there are. That is the easiest way for a court to toss you out. You mess up something in a notice, you mess up something in the adoption process, you don't file a report, you don't comply with the statutory requirements, you'll be out. And one of the cases I'll talk about today shows that very clearly. The two poster children or poster cases that I want to talk about quickly today, one is California and one is Florida. So Walker v. San Clemente, I know Tyson talked about this a couple of years ago. San Clemente adopted a beach parking facilities impact fee, collected the fee for over 10 years, amassed over $10 million. They spent a small portion of it to buy one vacant lot. They kept complying with what they thought were the reporting requirements, and they filed their 5-year reports. But those requirements also require that they do findings for unexpended fees. And their reports actually kind of showed that there was no need for the facilities. So that's why they hadn't spent the money. They also had trouble with a couple of citizen opposition to some of the things that they did propose. So they tried, but they didn't do so well. So they've been ordered to refund all that money. It's still in process. The refunding process has been going on for a couple of years now. Another interesting case, and this is probably more interesting to attorneys because it's got a lot of really interesting legal issues in it. Fernandina Beach v. State. Florida case, city of Fernandina Beach bought a water system, water treatment plant that had excess capacity. So they adopted an excess capacity fee to charge new connections to that. They thought they were planning ahead. Excess capacity, great. We'll have enough capacity to get us to 2020. And this was back in the early 2000s. Over time, it produced more revenue than they anticipated. A lot of different things happened. They get to the early 2010s. They decide they want to refinance their bond debt, good interest rates. So they go and they want to refinance all this bond debt and pledge the capacity fees. Local citizen wasn't happy with that. She had challenged the capacity fees. The legal strategy was to get a bond validation in front of the challenge to the impact fees and try and get a different level of review. Bond validation in Florida, you get an expedited process. You have a fast track at the trial court, and then you jump straight to the Florida Supreme Court for appeal, for review of that, on an expedited schedule. For a lot of different reasons, I think the court at the trial court level in the bond validation case just didn't like anything he saw and denied the bond validation. All I've found on it are the briefs by the city and by the plaintiff, Ms. Condon, and the Supreme Court appeal was withdrawn. So I think they probably all decided to pack up and go home at some point. But it raises a lot of interesting questions about equalizing costs to new development over time. Just because there's a need, is there a rational or sufficient nexus to support an impact fee? I think that our California case indicates that sometimes maybe there's not. There was a distinct perceived need that new development in the inland portion was going to require additional beach facilities. But their own studies showed over time that there wasn't enough of a need to actually build the facilities. So you kind of have to look at that and go, well, okay, maybe there's not always a need, even if a real need, even if we think it's there. You've got the possibility of developing your own data to support something. So if you have local politicians that see a need for an unusual facility, I think you can develop your own data to support the need for that, but you've got to be belts and suspenders approach, really document it. Another part of the legal basis, but I did everything required at the time of the adoption of the fees. Everybody's got home rule authority or statutory authority to do this. California's got a whole book of requirements. Florida has this in our statutes that we have to follow. They don't always apply just the law in effect at the time you created the fee. Fernandina Beach shows that. The court actually retroactively applied Florida's statute of section 163.31801. The standard of review was changed from deferential to local government decisions to placing a burden on the government to prove the need, prove everything about the impact fee by preponderance of the evidence. They had adopted, Fernandina Beach adopted this capacity fee in 2003, and there were some other technical issues later on that they thought they'd changed it, but they didn't provide adequate notice, so basically everything went back to the 2003 ordinance. The court didn't like any of that and retroactively applied this non-deferential standard of review, even though it was in a bond validation case, which should have put it under yet another standard of review. So, you know, it doesn't always work, even if you think you've done everything right. So follow the statute. If the statute says do something by ordinance, don't do it by resolution. A lot of local governments in Florida now are trying to avoid the 90-day requirements and all this. They don't, we don't want to do an ordinance every time we want to change it. They want to adopt a cost of living increase. And I say, well, how are you going to comply with the 90-day notice requirement if you don't know what that fee is going to be now? So you're saying, oh, in the future, here's 90 days notice that at some point in the future we're going to implement an increased fee. I think they should go back and do it by ordinance. Again, it's the easiest way for a court to shoot you down. Don't do it. Don't give them that opening. Some of the unresolved issues that we're drifting into is impact fees are for public infrastructure, aren't they? So when does an impact fee expenditure not count as infrastructure? There are some locations in Florida that now do mobility fees. I found one ordinance that seems to say it's okay for just them to spend that money on operations costs. City of Aventura actually has a mobility transit fee that specifically authorizes using it. Sorry, I have to speed up. That specifically authorizes using it on operations costs, and it's a local circulator. It was done primarily under agreement of the contributing property owners. So again, an unusual situation. What about providing money to nonprofits to build affordable housing? Is that still public? This is public money. It needs to be used in compliance with whatever constitutional restrictions there are on that. So you may cross the line from infrastructure to operations costs. You may cross the line from public to something else, quasi-public or private. What about privatization? We've got lots of jails that are being privatized now, garbage pickup, all of these facilities and equipment that we paid for with impact fees. What happens to those? If they build it, we need more capacity. I think the Walker v. San Clemente case showed that not always. You may have more development and not really have a need for more facilities. You've got libraries now. Those are transitioning from books to digital material. So do they still need as much space? Most of those library facilities were based on square foot per capita. It can still be used as meeting space, but it raises questions that I think as practitioners and local government employees we need to think about. We need to guide the process through this. And last but certainly not least, we collected this money, now what do we do? You got to spend it. You got to spend it in the time frames. That's what happened to San Clemente. They didn't use it, they didn't spend it. They weren't egregious about it, but they didn't do what they needed to do to maintain the validity of that money. This is one of the areas where I find local governments try and go it on their own a lot. And really, you have to step back from your CIP and look at it with a fresh set of eyes. Just because a project's been on the CIP for 4 years and it's fully funded, don't assume you can't spend impact fees on it. Move the money around, find the projects that are most clearly new growth related and throw as much impact fee money towards that as you can, and then backfill with less restricted money. So pick your most restricted funds and find places to spend those in your CIP first. And then you've got room to backfill with gas tax or whatever else you have that's less restricted. Identify the projects and then read the descriptions. Don't let there be a project you're spending 100% of impact fees on and it has repair and replace in the description. Don't do it. That's a red flag. You're asking for trouble. Make sure you do your annual reports. When somebody sues you 5, 6, 7 years down the line, you will be so glad that you did, because you've identified every project. That project is justified. You know where the money's been spent. And rather than having to rat around in old computer files and try and find that information after the CIP guy has been gone for 3 years, you'll have it on the shelf, pull it out, and you'll be ready to go. So hopefully that gives you somewhat of an update. Same legal principles. We're still wrestling with them. And we've got some new issues that we're also facing that I think we can all work together to guide through impact fees and make sure that we don't get a lot of bad case law out there.
Okay, gosh, great discussion so far. I hope I can add to it. One of the things that strikes me as we discuss legal issues associated with impact fees is that things that appear so clear to us here in this room as practitioners in the area are not well settled in the courts. And that, I think, sometimes is the mismatch. We frequently see, as we saw in the Kuntz case, which we talked about a few years ago, and I will touch on it for like the 4th time, but it will be very brief, I promise you. Is a perfect example, though, where a court could have been more precise in their language and their analysis, and that would have helped people in this room. I've divided my comments into 2 areas. One is when the consultant is still around. That's when you're working on your methodology, you're developing your ordinance. That's a particular phase. You can tell from this image that you're in very good hands at this point. You have the experts still local. But then at some point, the consultant's going to leave, and you're going to be on your own, and they're out of there. And then the question is, what happens then? And I think Susan touched on a number of issues here that come up after the consultant is gone. And there's some things you can do while the consultant is still on the ground to avoid problems later. But as Susan alluded to, I think it's important that you maintain contact with your consultant afterwards. So I had a couple thoughts as you were talking, Susan. I'm just going to share them while we're at this point. I have to take that off the screen. I can't. I think what happens frequently when we go into the impact fee process is that everybody's doing their job, and we get a bit siloed, as they say now. The consultant says, I know how to calculate an impact fee. I do it all the time. Here's your impact fee report. And staff says, it's my job to hire the impact fee consultant. We've done that. There may be some other involvement. I think what we have to remember is to involve local counsel, if that's who's going to be responsible for the legal aspects, throughout that process, and Susan touched on that. And then I think as staff, if we can prepare our elected officials and our higher ups for the reality that we may need to call in the experts later when we have questions. so that we can avoid very simple problems. I tend to be fairly conservative in my view of things. I think Susan alluded to that as well. It's fairly easy stuff to comply with. And we're usually talking about a low amount of dollars, small amount of money, sometimes just to take a more conservative approach. So while the consultant's still around, let's talk about some issues there. It's difficult for me to tell. Okay, very good. So we're going to talk about ensuring benefit when some aspects of new development is exempt. Common question always comes up. I'll share with you how I usually advise clients on that. Identifying the use, and this makes a difference, or at least it did in Florida in a couple of cases I'll go over. Whether you're talking about a facial claim, that is, right when the ordinance is adopted, there's something wrong with it no matter what, it can't be defended, or an as-applied claim, and that's one where your ordinance is fine, but as it's applied to me, there's a problem. So we'll talk about that, looking at a couple of Florida cases. We'll look at the question that comes up frequently, can you include financing costs and impact fees? And apparently we're going to get to this question probably in a later session, but I'll touch on that briefly in the Florida context. And then finally, does Kuntz apply to impact fees? And that gives us a chance to look at the mess that was created there. And then we'll talk about when the consultant's gone, and if we have time, we'll touch on the Muir case, which was decided by the U.S. Supreme Court this past year. So when the consultant's still there, as Susan said, the law that applies to impact fees applies throughout. If you've been coming to this for 15 years, you've seen this slide probably 15 times. But this is the dynamic. At one end, you've got new development. At the other end, you've got the CIP. And there's a connection between the two that runs in both directions. And that's sort of consistent from Florida's dual rational nexus test. And it's also consistent with some of the state statutes that have been identified or that have been adopted. And as Jerry pointed out, this is essentially what distinguishes a fee from a tax. It's interesting if you go through the Florida cases, how frequently, I don't know, maybe there are 6 or 7 of them that mention the dual rational nexus test, and they harken back to the Hollywood Inc. case. They don't specifically identify what constitutional provision it violates, but the presumption is that it's that one, that if you don't comply with that test, it's a tax and not a fee. So let's talk about St. John's and the Aberdeen case. St. John's was decided by the Florida Supreme Court in 1991, and it looked at a number of interesting constitutional questions, actually. I'm going to focus on just a few of them here in that needs and benefit analysis that we have. On the needs prong, the court basically upheld for the first time some detailed methodology. It was really an impenetrable methodology. It could not be attacked because Jim did it. And the court said he did it right. The needs analysis, it went through the calculation, it mentioned the credits that were given, and it upheld that needs prong. And so when houses develop, they create kids, at least 44 for every 100 houses, and that creates the rational basis for adopting a school impact fee, which is the first time that had been upheld in Florida. The attack that the home builders in Northeast Florida made, however, on the needs prong was that, wait a minute, there are quote unquote many houses that won't have kids in them and they don't have an impact. And the court rejected that argument, and it said we look at least on a facial claim, these types of questions on a community level. We're going to look at all the houses, and generally speaking, every house over time will have the tendency to create kids. Oh, houses create kids, okay. Over time. And the school district certainly has to be prepared to provide schools to that house. So we're looking at the unit and not necessarily the user. On the benefit prong, this is the one that comes up, even if you're familiar with the facts of this case, in other type of factual situations. So here, if you're looking at what I'm looking at, you have the school system, and then you've got a blue blob that represents the cities and a white area that represents the counties. So the schools are provided throughout the county and the cities. So at the county level, you've got a development occurring in the unincorporated area, and they're receiving a benefit from the schools. They also are paying impact fees to the schools. In the St. John's case, the ordinance said, as they frequently do. Again, I think this is a result of everybody's doing their job, and sometimes these things don't get thought about until we're getting very, very close to the adoption hearing. Did the cities ever sign on? I don't know, I'll call them. Do we need to count the cities? Well, I don't think we need to count the cities. Yeah, we need to count the cities. these are types of questions that need to be thought about from the very beginning because they have legal implications, and St. John's learned that the hard way. Their ordinance said that if a city didn't sign an interlocal agreement, well, let me flip it here. What it said was if a city signs an interlocal agreement saying they want to allow their developers to pay impact fees, then those cities would collect impact fees, but if they didn't sign such an agreement, presumably impact fees wouldn't be collected in the cities. And big surprise, the cities didn't sign those interlocal agreements, so you had a system where the cities were benefiting from the schools, or city development was benefiting from the schools, but it was not paying an impact fee. So the court said that that creates, by definition, a failure on the benefits prong of the dual rational nexus test. And what they said is there can't be disproportionate benefit. No, there is no requirement that every fee payer benefit, or that each person who benefits pay an impact fee. But it said substantially all the population that does benefit, substantially all that does benefit, has to pay the impact fee for that facility. So that was 1991. The question was, what is substantially all? Well, we knew in 1991 it meant an entire city. Okay. When we answer these questions for clients later, it might mean, what if we want to exempt downtown development to encourage development in downtown? Is that substantially all if they actually impact the facility? What if we want to exclude certain types of economic development uses? Well, that's the question that I always come back to when I'm answering that question for my clients. About 10 years later, in 2000, the Florida Supreme Court, well, this is the first case I did for the National Impact Fee Roundtable on a chalkboard. The Florida Supreme Court took up a question that, some of these questions that were left open in this St. John's case previously. Here you had a situation where Volusia County was charging a residential impact fee for schools to all residential developments, including those that were deed restricted as adult-only communities. And the one that sued them had deed restrictions, covenants, conditions, and restrictions that were taken up by the court, basically held to be valid, that said nobody over the age of 18 could live there. And the county said, we're charging you a school impact fee anyway. And this went all the way up to the Florida Supreme Court. In terms of the need prong, the argument that the county made was even if there can't be anyone living there over the age of 18, under the age of 18, they still create a need for schools because here in Volusia County, we provide some services all the way up to age of 21 for people from 18 to 21, some sort of special ed type of services. And the court said that's not enough. That's a possible or an incidental benefit that's not sufficient, that what creates the demand for schools is kids, and they don't have kids here. In fact, the facts showed that the youngest person who ever lived at Ormond Beach, Aberdeen and Ormond Beach, was 42 years old. What about the benefit side? Well, they argued there's some benefit that would accrue to them because, in fact, some of these schools are used for refuge during hurricanes. So all the old folks from the Aberdeen by the Sea or Aberdeen Ormond Beach could come and have to evacuate to the schools. And the court said that may be true, but again, that's just too tenuous. It's not a substantial nexus there. The benefit is too tangential, too attenuated. So the court overturned that aspect of Volusia County school impact fee. And again, we're looking at the unit and not the user. They distinguish this from a discussion in St. Johns County related to that situation where one house may not have kids right now, but it may later, and they said this is unique. I'll point out very quickly and then move on here. This last bullet refers to community-based analysis versus subdivision analysis. The language in Hollywood, Inc. is sort of interesting when it articulates the dual rational nexus test. It talks about the benefits and the needs created by the subdivision. And I think if you read these two cases together, it explains or it clarifies some confusion there, that when we adopt the fees, we're looking at the community level. When we look at how they are applied, we look at more the subdivision level. Okay. Question comes up frequently, can we account for financing costs in our impact fees? Can we count those in the fee and then spend them on financing? I'll go through this one fairly quickly. Sarasota County case, right where we're sitting this morning. The county required residents to switch over from septic to sewer, and in that process charged a capacity fee, and a portion of that was going to be used to pay debt on existing sewer capacity. The folks who wanted to keep their septic systems came together and filed a lawsuit, and they said that since almost half of the fees expended are going to be spent in this way, we've got a legal problem here. The county said, look, given modern day financing, and in this case concurrency or APF requirements if you're in a different state, we have to be able to use current revenue flows or revenue streams to pay existing debt in order to permit further expansion in the future. The court ended up sending this back down for a decision, but what the court said, which I think is significant, is we're certainly not going to say that that is never a legitimate use of an impact fee or a capacity fee, because in some cases it simply might be, and we're just going to have to send this back down to the district court, the circuit court, and ask them to carefully review the calculation of the impact fee and the intended expenditure purposes, and then we'll go from there. And the case never came back up, so presumably it got resolved at that level. Does Kuntz apply to impact fees? This is a slide from 2013. These are pictures from 2013. And you recall that the majority in Kuntz. Now, Kuntz is the case where they said that when you, on an ad hoc basis, at a permitting basis, point in time, require a developer to give a certain amount of money, proportionality has to apply. The principles of Nolan and Dolan have to apply whether you're asking for money or asking for land. Fair enough. In concept, probably most people agree with that. But for those practitioners, and again, getting back to my original point to you this morning, to us, that left a lot of questions open. What do they mean by monetary exaction? I read a case this week out of Utah that referred to only ad hoc impact fees imposed at the time of development trigger Nolan and Dolan. Well, that's not an impact fee in my mind, you know. So we've got a lot of confusion in the terminology floating around out there. So what the court said, the majority said in Kuntz was, that's okay, the states and the local governments will figure this out. And they said that Nolan and Dolan do apply to quote unquote in lieu fees. Oh, wait a minute, in lieu fee is a legislative fee to me. We wouldn't normally apply Nolan and Dolan to that. In San Clemente, in fact, the San Jose case, which is a housing in lieu fee in California, said as much a few years later. When they said that it applies to impact fees, in lieu fees, they cited an impact fee article. And then they said, but of course, Nolan and Dolan doesn't apply to property taxes. Okay, fair enough. User fees, okay, wait a minute. And similar laws and regulations. Okay, well, thanks. I mean, as an attorney, I mean thanks, but as a local government practitioner. So the quote there at the bottom is from Justice Kagan's dissent, where she recognized that we're creating a lot of confusion and we're missing an opportunity to correct it today. She drew some of these distinctions between some of these types of charges and said maybe today's majority accepts these distinctions, then again, maybe not. And there was some more colorful language in a footnote. So, where's the majority right? Well, in DABS, there's a lot of litigation going on in Maryland in the last few years related to spending impact fees, how they've been spent, whether they've been spent on time after the consultant is gone. And in this case, DABS, basically they recently held that Kuntz, Nolan and Dolan do not apply to impact fees. And they had really decided that right after Dolan in 1994 in the Waters Landing case. But they went on to say, citing Kuntz, citing the actual language of the majority opinion, that we're not going to look at Nolan and Dolan on that proportionality requirement, a taking claim, for legislatively imposed, generally applicable fees. Last year in the Utah Supreme Court, a case came up challenging the level of service standard that was used. The court looked at the record presented, it heard arguments, and it had briefs, and it had briefing. And still at that point, they were unable to determine under Kuntz whether that case should apply, because they couldn't determine whether or not a level of service was legislative or not. And they footnoted this problem by saying the difficulty in answering this question stems in part from the Supreme Court's lack of clear guidance. And they cite the majority in the dissenting opinion. And that was sent back down. And then just this year, the Utah Supreme Court, we're going to touch on this case here in a moment, hit it again And when they denied a taking claim related to the spending of impact fees, they said, however, if you had brought this claim at the time the impact fee was adopted, you could have had a taking claim. And by the way, that would have triggered Nolan, Dolan, and Kuntz. So again, we're just really getting it all over the place. So let's talk about what happens when the consultant's gone and you're on your own. This is where I think we're starting to see more of the challenges. It could be that I think there's fewer impact fee activity out there today in terms of adopting new ones or increasing existing ones. So this might be where the plaintiff's focus has now shifted. So we're going to look at taking claims at the time the fees are imposed or collected, post-adoption changes in the CIP, which we've talked about a bit this morning, common challenge from a practical level again, and the failure to spend fees within the required timeframes. This from the Colorado Real Estate Journal this past year, trust but verify. So this is a developer type of perspective where they're encouraging the development community to go into their local government's impact fee systems and look at what's going on. And indeed, we're seeing this. My experience with this, again, because we know impact fees and you are my typical clients, is that people are generally speaking doing it correctly. However, there are gray areas. Unfortunately, when these things get politicized, and sometimes when we get to litigation, nobody cares about the gray areas. And I've seen a lot of good planners get sort of victimized by making reasonable decisions that don't look reasonable to others. So this, I think, is where the caution comes in. Okay, so getting back to that Utah Supreme Court case, challenge to fee expenditures. So the developers challenged the failure to spend the fees within the required time frames, and in some cases, spending the fees on the wrong category of public improvement. So part of their claim was a taking claim. So they were saying there's been a taking occur here. And as I mentioned earlier, the court said there's no taking claim that can be brought for failure to timely spend or misspend impact fee revenues. You could have brought that earlier on. I think what's interesting about this case from a legal point of view is, well, why did they even assert a taking claim for failure to spend impact fees at a certain time? They were alleging that since you didn't spend our fees in time, or you spent them on the wrong thing, we didn't get a benefit back. Well, that's an interesting argument because benefit isn't raised in Nolan, Dolan, and Kuntz. Those cases are just about whether or not the initial impact was measured correctly. So it's an interesting thing to come up. So it gets back to dual rational nexus, and they may have had a claim under Utah law otherwise, but not as a taking claim. Again, a case we've seen in earlier years, but I'll mention very quickly to set up some cases I want to talk about out of South Carolina here in a minute. This is that Germantown case out of Wisconsin where the question, basically a park or actually an aquatic center impact fee was adopted. And this is important. It's kind of funny in some ways, but on the other hand, I can kind of see exactly how this develops. They knew they needed aquatic facilities in this community. So the question was, can a municipality spend aquatic center impact fees on something other than what was originally contemplated when the fee was adopted? The fee basis or the fee study estimated the cost of an aquatic center or youth center at $1.8 million. And that cost was generally speaking based on the cost of a pool that the city had decided to build. I've put the specific terminology up here because it becomes relevant. The fee was called the Aquatic Center Youth Center Impact Fee. The statute said that fees then had to be spent on, quote, capital costs for which the impact fees were imposed. When they got sued, the plaintiffs said that means the particular $1.8 million swimming pool, and that's all that it can be spent on. Well, things changed after the adoption of the fee, and the city or the village ended up taking the position that it didn't have to be on the pool itself. It just had to be on the category of facility. So between 2001 and 2002, believe it or not, by referendum, I think twice, the town voted not to have a pool, but to have a spray park. But they didn't do a new impact fee study in between, okay? So the question was, does a spray ground bear a reasonable or rational relationship to the need for quote-unquote public facilities? And the court said it did. And in Wisconsin anyway, and I wouldn't advise this necessarily everywhere, but the language in this fee study was sufficiently broad to encapture different kinds of park facilities or aquatic facilities. They, quote, made a good faith and informed estimate of the sort of costs it expected to incur for the kind of facility it planned to provide. Wow, remember when courts used to use language like that? Flexibility to deal with the contingencies inherent in such planning is what's required. So the court was fairly forgiving there, which I think has always been sort of the notion with impact fees. I'm not so sure anymore, given the tenor of some of the cases and the language in some of the cases, particularly the Cooch case, which in my view as a government attorney bordered on hostile at times. Okay, so South Carolina, the changing of the CIP, what have we seen? 2 suburban counties near Charleston, South Carolina have been sued recently by a former associate of mine for their failure to spend impact fees in time or correctly. The first one was in Berkeley County, where they've just recently refunded $6.5 million in impact fees to settle that claim. Now, they had collected about $12 million and spent about half of that. So, you know, they did a lot of it correctly. But over time, the CIP changed and not all of the impact fees were being able to be spent. South Carolina has a unique, I think it's unique, statutory provision related to when fees have to be spent. It's certainly confusing if it's not unique. It says the fees have to be spent within 3 years of the time at which they were scheduled to be completed. Actually, it just says scheduled on the CIP. So that leaves some confusion, but maybe some flexibility. So 3 years from the time they're scheduled to have been provided. So you have to have a 5-year CIP and it has to be updated every 5 years in South Carolina. What had happened in Dorchester County, which was then sued, when Berkeley County, when the plaintiffs prevailed in Berkeley County, they went over to Dorchester County, which is just next door. They appear to be poised to make some refunds, although they've just filed a motion to dismiss, so that's thrown up some uncertainty there. But again, we had CIP items that were planned within the appropriate time frame under South Carolina statute, but they were delayed. And what I've been told about this case is that a lot of improvements were moved later in the CIP to keep them, to give the counties flexibility in when to spend, to move, basically to move that 3-year time frame. Okay, but 2 major improvements for whatever reason weren't moved. And that's the basis of the refund in Dorchester County. So again, it's that focus on the details after the consultants are gone that I think we often lack. Now, a few years ago, Dwayne, and I don't see Carson yet, but Tischler Weiss and I did an impact fee in Georgetown County, South Carolina. This is during the height, or right at maybe at the tail end of the recession, or the boom rather, so we didn't know what was about to happen. Adopted a number of impact fees, one of which was a road impact fee. And some significant part of that fee, I don't remember exactly, let's say 25%, was based on a major road improvement in a certain part of the county. When the economy turned, they realized they weren't going to build that road improvement. And they called and they said, what do we do? And I said, well, my conservative answer is, if it's 25%, that I suggest you refund to those who paid it 25% of the fees they paid and reduce your fee by 25%. And that's what they did, and they never got sued. And they still have a road impact fee that I think is defensible in that respect. So it can be done. So it's thinking ahead and paying attention, I think. I'm going to stop. We're not going to go through more because we only have a few minutes left, and I want to have some time for questions and answers.
Can I just add?
Yeah.
Building on what Tyson just said about making adjustments like that, everybody in local government tends to, not everybody, but a lot of people tend to, it's an either or. It's all or nothing. And there are countless opportunities to make adjustments that are reasonable and rational like that, that can avoid pushing things to the ultimate battle. Now, sometimes there are absolutely times you've got to go into court and fight it out, particularly on authority issues and things like that. But in impact fees, assessments, those areas of local government revenue, you have countless opportunities to make reasonable and rational adjustments in many instances that can avoid the disaster of having to go to court and fight everything out and all the impacts that it has, not least the cost. So don't forget that there are ways to go around things. It doesn't always have to be a straight path.
That's right. Any other comments from the panel before we open it?
One quick one. The allusion been made to the litigation in Maryland. over refunds. And this comes out of Anne Arundel County, and unfortunately, what had happened was someone in the administration had opined that impact fees could not be used to expand any existing school. They could only be used to build new schools, which of course meant you had to save the money up for an extended period of time, which ran then into the refund period. So they kept playing games to extend the time frame, extend the time frame, and eventually got embroiled in all this. And what it came from was that opinion, completely outside of any impact fee types of issues, that you couldn't spend the fees to expand existing schools. I've also heard that you can't use it to expand existing roads. And these things creep in here, and all it does is complicate it and put you at legal jeopardy. What you've got to do is spend the money for the benefit of new development, which means expand. It doesn't make any difference if it's an existing road or a new road or an existing water plant or any of these other things. Expand the capacity and then service the growth.